Yeah. Okay, Joan didn't exaggerate about this bill. I've been around a long time. It certainly is the worst piece of labor legislation in terms of being against the ordinary worker that I've seen in my whole career. And I want to take you through it in some detail, but I'd like to take you first to the diabolical core of what this bill does. And I think you have the bill in front of you, most of you, eh? Yeah. Section 89, which is on page 25 in my version. It may be on a different page in your version. Section 89. And I'll put all the pieces together for you a little bit later, but just so you get the core plan that's in this legislation. So Section 89, if you're not used to legislation, there's subsection 1 that just passes it just after, and this is subject to subsection 2, so we'll look at section 2 in a little while, subsection 2. The jurisdiction of the mediator arbitrator to determine things under section 88, I'll explain that to you in a little while too, is subject to the following limitations. This is their plan for you. A, there must be 4 bargaining units of unionized employees for each health authority. That is to say, for the provincial merged authority is one health authority, and the IWK Health Center, which is the other health authority under this act. So there's to be 4 bargaining units of unionized employees for each of those authorities, namely, and they're named, a nursing bargaining unit, a healthcare bargaining unit, a clerical bargaining unit, and a support bargaining unit. Doesn't sound too bad, right? B, all unionized employees who occupy positions that must be occupied by a registered nurse or a licensed practical nurse must be included in the nursing bargaining unit for the health authority that employs those employees. Okay, so one of the bargaining units is a nursing bargaining unit, and by the statute, it's going to be both RNs and LPNs. C, each union, and then there's a sub-I, may represent only one of the 4 bargaining units for a health authority. A capital district health authority, NSGEU represents all 4. This legislation prohibits NSGEU from representing any more than one of these provincial health authorities. Okay, there's a few more pieces to go together, and must represent the same type of bargaining unit for each health authority. Okay, so you can only represent one. Let's say it was service support at Capital Health, then the one that you have to represent at the IWK, whether you have any members or not, is service support. Or if you represent healthcare for the merged health authority, then you must represent healthcare at the IWK, and so on, right? So there's only 4 bargaining units. Each union, NSGEU, is prohibited from representing more than one bargaining unit, and there has to be the same bargaining unit at both the merged authority and the IWK. And under D, to be eligible to represent a bargaining unit, a union must immediately before the coming into force of this section represent the unionized employees in a bargaining unit of the same type for at least one district health authority. So for example, CUPE, which represents and has no members at the IWK, will be representing one of the bargaining units at the IWK because they represent a bargaining unit in Pictou or in Cape Breton or wherever. So as you try to piece this together and do the math, have in mind there's about 24,000 workers that are covered by this legislation, about half of whom are NSGEU members. And if you took the existing bargaining units, NSGEU has quite a broad majority in the healthcare bargaining unit and in the administrative clerical bargaining unit, has the plurality in the service support bargaining unit, if this is provincial-wide, and is not in a majority position in the nursing bargaining unit. So if you had elections, the people in those units would vote, and they could pick NSGEU if they wanted to, for all 4, or for 3, or for 2, or for 1, or for none at all. But under this legislation, NSGEU will only be permitted, it's prohibited from representing more than one unit. There's a design in it which is One, that the nursing unit will be represented by the Nova Scotia Nurses Union because they have to represent, they must immediately, before the coming into force of this section, represent the unionized employees of the same type for at least one district health authority. So the only bargaining unit that the NSNU can represent under this theory is nursing. And nursing will be all the RNs and all the LPNs in the province, except at IWK, where it'll be RNs and LPNs. So the legislation is designed that will be the result for RNs and LPNs. This doesn't just hurt NSGEU members. Half of the members of CUPE in the province are LPNs, or more than half. They have to be represented by somebody else under this act. So then you're left with the service unit and the clerical unit province-wide, and same at the IWK, and the healthcare unit. But then you have to look a little further for the second part of the diabolical nature of the scheme, and that's in section 90. In determining the appropriate composition of bargaining units for each health authority, the mediator arbitrator shall consider the community of interest among unionized employees in each proposed bargaining unit in respect of the nature of the work being done, such that A, the nursing bargaining unit is composed of all unionized employees who occupy positions that must be occupied by a registered nurse or licensed practical nurse. I said this twice to make sure it gets through. B, the healthcare bargaining unit is composed of all unionized employees who, 1, occupy positions that require them to be engaged primarily in a clinical capacity to provide patient care. So most of the people in the healthcare bargaining unit that NSGEU represents at Capital Health will not be in this bargaining unit. This will be basically the licensed professionals who actually directly provide patient care. So where are they going to go? The rest going to go, we'll see. And then the third unit is C, a clerical bargaining unit composed of all unionized employees who occupy positions that require them to be engaged primarily in non-clinical capacity. Non-clinical capacity to perform functions that are predominantly clerical or administrative. That's not too different than it's going to be provincial. And then the support unit composed of all unionized employees who occupy positions that require them to be engaged primarily in a non-clinical capacity to provide operational. They're the present district health authorities or the new health authorities. So what are these sections? What are they about? Section 23 to 26 provisions. Right now, under the Trade Union Act, your collective agreements are about to expire. Another union could apply to displace NSGEU, and the Labor Board would what? Hold a vote. That's what Section 23 to 26 would allow them to do. It doesn't happen very often, but it's a right that you've got to get a different union if you're fed up with the old one. That's not going to apply anymore to the district health authorities or to the new health authority. So Section 28 1B2, those are the provisions of the Act that permit the Labor Board to change bargaining units that have been set up in the past. So the bargaining units we looked at a little while ago, can they ever be changed? They can never be changed. Sections 29 to 32. Section 29 is the decertification provision. This doesn't happen very often, but if you wanted to, if you're fed up with NSGEU, you can apply to the board and they will hold a vote on whether to decertify NSGEU. It's a freedom that you've got. Not anymore. It's not permitted under this revision here. Section 30 is a voluntary recognition provision. This is ultra technical, but I will mention to you that the bargaining rights of NSGEU at Capital Health are voluntary recognition bargaining. That's not going to apply anymore. Makes for an interesting question. Section 31 is what I mentioned before. It's probably most fundamental about these provisions that are being canceled out. That's the provision that allows the Labor Board to determine what the bargaining units should be and to determine the wishes of the employees in those bargaining units. Not going to apply anymore. The other sections, 40A and 40B, are not particularly significant. They're the first contract provisions. And they already stripped them of anything that had any meaning. So even though this section seems really harmless, if you connect it to the core thing before, they're saying there's going to be 4 units, 1 union in each of those units. They can never be displaced. They can never be decertified. The units can never be changed. The employees can never have a say as to whether they want to have the union that they've been given or displace it or kick it out. Gone. Forever. I have never seen anything like this really before. They are, obviously the whole bill is designed out of fear that you and other healthcare workers will pick a union that they don't like because the union is doing too good a job for its members. So this Section 83, it seems really harmless, but think about it. It's probably the most radical thing in the Act. It's forever, can't be changed, doesn't matter what you wish, doesn't matter what your grandchildren wish. Can't be changed unless the legislation is changed. Hopefully someday we'll kick these guys out and get a better government. Okay, so now the nitty-gritty of this act. Starting at section 85, there's a process described, and the process is kind of shocking as well. The process is, section 85, within 7 days of the coming into force of this section, let's say they ran within 7 days after that, sometime at the end of next week, that the district health authorities and the unions can agree on a mediator arbitrator, and if they can't agree, the minister will appoint one. The minister is obviously going to be appointing one. So you have this mediator arbitrator. So that's a concept. Mediations, you try to help people get agreement. Arbitrators, you impose the agreement. This puts them together into one person. Section 86, this is one that you will want to mark and come back and look at another point because I don't think you'll see anything in our history like this again. Section 86(1). Representatives of the district health authorities, the employer, and unions shall within 14 days of the appointment of the mediator arbitrator enter into mediated negotiations with the assistance of the mediator arbitrator to determine, okay, the employers and the unions with the assistance of the mediator are there to determine from among the unionized employees of the district health authorities, the appropriate bargaining unit for the merged health authority and the IWK, including appropriate composition for each bargaining unit. That actually sounds kind of reasonable, unless you were going to do it by the labor board the way we always have done it and the way that everybody has found fair. But anyway, just hold that. But look at B. This is the one, if you have a pen, to write a number under it. The bargaining agent that's to represent each bargaining unit. So the employer has a say in who is the union that's going to represent you. We don't have that here. We don't have that in Canada. The Trade Union Act, the employees decide whether they want a union or want to kick it out or replace it with another union. The employer doesn't get a say in that. But under this act, the employer has a say in the bargaining agent to represent each bargaining unit. That's kind of interesting, right? Except for what's missing. You don't get a say. The employer has a say, you get no say under this statute as to who's going to represent you in bargaining with that employer. And then in C, whether in respect of each bargaining unit, this is one you have to be really focused on, only a collective agreement to which the bargaining agent is determined under Clause B is a party, the one basically the employer tries to dictate, is a party to remain in force to all unionized employees within the bargaining units. So one option is to have the union that's selected after the employers had their say, to say, we'll just take our collective agreement. Forget all the other collective agreements. So bear in mind, NSGEU can only represent one of the units. So what they've opened the door for and authorized is one of the other unions that is selected. There's 3 other unions. I'm not criticizing the other unions. 3 other unions can just say, we don't like that capital health agreement. We'll keep the one we've got. You have a lot of things in your capital health agreements that people don't have in the other sides. Some really important things at the stroke of a pen, not with bargaining, not with ratification, not with anything. You can lose that. Now, I don't want to overstate it. Perhaps I've overstated a little bit. There is an option as well that all of the collective agreements pertaining to the unionized employees at the bargaining remain in force. This is the typical thing that happens when there's a merger. All existing agreements continue until they're renegotiated. Hopefully, in this whole process, that'll be the outcome rather than somebody just stripping your collective agreement on day one. It's there, it's a risk. For the government to put that on the table as an option means it is an option. And D, the integration of seniority of unionized employees in each bargaining unit. If you have a provincial-wide bargaining unit, seniority is going to be a very significant right when they start to cut services some places, and who's going to go, and seniority obviously is really important. So that's on the table for the mediation. And what's missing from it, and I'm repeating myself, but it's so fundamental, is the employer has a say, the existing unions have a say, but the employees have no say. 24,000 healthcare workers, they have no say. So that's the mediation stage, and under 3, the mediation continues until there's an impasse. Duh. Well, there obviously can't be agreement. I mean, they've put the cat among the pigeons between the unions. They've created a situation where one union's gain is the other's loss, one union's membership's gain is the other's lost. So there is going to be an impasse. And of course, because of the clause I started with, the employers aren't going to agree to anything less than what that's got laid out in the statute as the default. So there's going to be an impasse. And that has to happen, or if you look at subsection 3D, 45 days is the limit of the time. So, okay, so if this thing came in next week, so, towards the end of November will be the end of the mediation phase if it doesn't have an impasse sooner, which it very likely will. And that takes you to Section 88 and back to where we started. Section 88, where the mediated negotiations are terminated before an agreement is concluded on all the matters to be determined under 86.1. That's the list of things, the units, the bargaining agent that's going to represent the unions, whether they have any collective agreement left, and so on. If you can't decide on all those things, the mediator arbitrator shall conduct a final and binding arbitration to determine the matters referred to in that subsection that remain to be determined. So you'll have a government-appointed arbitrator who's going to decide who represents you, and you don't get a say. So Section 89, this is where we started, so let's just go back to it together. Section 89, the jurisdiction of the mediator arbitrator is limited. It's got the following limitations. So they had a real problem, right? If you get any sensible, experienced, decent mediator arbitrator, are they going to impose a minority union on a majority of people? They would have no reputation left in the country at all. However, they're subject to the limitations. They can't do anything better than this. There must be 4 bargaining units, blah, blah, blah. All unionized employees, well, the LPNs and RPNs, and again, back to paragraph C, each union must represent only one of the 4 bargaining units for the health authority and must represent the same type of bargaining unit for each health authority. So that's the default through all that process, and nowhere in it is there any say for you or for the other, for the 24,000 health workers. I heard that, I'm sorry to be, you can get mad sometimes. I heard the Premier saying yesterday or today that they've done it this way because otherwise CUPE and Unifor will be wiped out. Now, CUPE and Unifor are both very fine unions, right? And their members believe in them, and they can't have a vote as to who they're going to represent. I mean, I find it so incredibly insulting to CUPE and Unifor, who represent people right across this country, and they were never dictated by the government that they'd represent people. But in Nova Scotia, they're going to dictate that CUPE and Unifor have a bargaining unit where the majority of members are you. So I'll just go a little further because I'm holding up the progress here. And so back to 90, there's the nature of the units. The units are going to be pulled apart. If I was in a healthcare bargaining unit, I would be concerned because it's going to be shrunk down to very little. People will be shuffled around. But in subsection 2, I probably should end up pretty close to subsection 2. In determining the bargaining agent to represent each bargaining unit, the mediator arbitrator shall consider whether the selection of the proposed bargaining agent will A, be conducive to stable and harmonious labor relations between the health workers and the unionized employees. In other words, pick someone that represents the employer's interests and not yours. And that's a requirement for the mediator to take into account. And then promote the efficient and effective and efficient provision of health care to patients at healthcare facilities. That's a little more neutral in nature. Where's paragraph C that says take into account the wishes of the people who are going to be affected by it? There's no paragraph C, right? Okay, so the rest of it's kind of technical. If you section 91, it's about the procedure. Subsection 2 of 91, the mediator arbitrator can determine the procedure. Subsection 3, the mediator arbitrator shall permit the district health authorities and unions to present evidence and make submissions. So the district health authorities will make submissions on who should represent you, because they get a say, even though you don't. They can hold a hearing under 492. They can mediate again if they want to. Section 93 and 94 deal with the powers then to issue an order. But I think have in mind subsection 2 of 94, where an order provides that all the collective agreements pertaining to unionized employees within a particular bargaining unit remain in force. The order may specify which unionized employees in the bargaining unit are be covered by each collective agreement, B, modify or restrict the operation or effect of any provision of any collective agreements, and define the rights with respect to the collective agreements of any unionized employees. None of you are old enough to remember when the Cape Breton Regional Municipality was created back, at least one person. And there was a huge uproar in the labor movement that put an end to this as a practice. In making its decision, there was 9 bargaining units all combined together. The Labor Board issued an order that modified some clauses in the agreement related to job security. And that's the last time in Nova Scotia that ever happened, because when QE2 was created shortly thereafter, the members really rose in a revolt to be certain that that could never happen again. But it can happen again under this legislation. I'm sorry, are there any RNs here? Yes, they haven't forgotten about you, the RNs. Section 98. Before April 1st, 2015, neither a district health authority nor a union may give a notice to bargain under blah blah the Act, or bargain under Section B, or continue negotiations for an Essential Health and Community Services Act. When this Act passes, it will be against the law, it'll be prohibited to bargain on behalf of those nurses who have not yet got a collective agreement. So I understand, and maybe I'm wrong, but I talked to Linda Power earlier today. She said the conciliator, and you may know as well that on the Essential Services Agreement, there was a provision for sending it to the board, and the board was going to issue an order by October 15th. So in the ordinary scheme of things, the nurses would have their right to strike back sometime in October, but they're not allowed to do that. They're never going to get that collective agreement if this bill passes. Section 99 and 100, these are all very heavy penalties and prohibitions against striking when it's prohibited to strike, which is till April 1st, whenever. Okay. And so really, I'm sorry, I'm sure there's chatter because you're getting a little bit bored, but that really is the Act. I've taken you through, but I'm sure you do have questions, so if anybody has questions about how it works, there's a person way down there. Maybe you could MC, yeah? You're going to have to stand up and you're going to have to speak loud.
Because we don't have mics, so.
I have a two-part question. Do you think that any or much of what you just went over with us is legal? And also, will there be any way to punish people if this is found to be illegal or brought into effect?
Repeat the question.
Yeah, repeat the question
No,
because...
you repeat.
Me repeat? I didn't hear the second part.
So
You repeat it.
So the question is any of this, is it illegal, and is there any way to punish people that put it through if it is illegal? Did I catch it?
Yeah.
Okay, so you're asking legal grounds for us to come after the government on this, right? Okay.
Any law in Canada has to comply with the Canadian Charter of Rights and Freedoms. And under the Canadian Charter of Rights and Freedoms, people have the freedom of association. It's a fundamental freedom, and it includes freedoms related to collective bargaining. And I haven't done a legal opinion or anything on this, but I can't think of any example where freedom of association is being abused the way this legislation does. But, and this is something a thing I have as a lawyer, don't put your hopes in legal proceedings. The courts are not really your friends. This NSGU will fight to the death to take every step, I'm sure, to challenge this legislation if it's enacted. But I think it's kind of in your hands the next 3 or 4 days to try to get as much public opinion against the bill as possible so that, down the road we'll be able to remedy this thing. And there may be a legal challenge that'll do that.
Other questions?
In an email that was sent out today by the NSGU, there was a statement saying that under the new agreement, the employer will have the opportunity to tell the mediator arbitrator what aspects of a new contract that we have to accept.
Correct.
Okay, I want you to explain that. So what's the point of bargaining? There's not gonna be any bargaining anymore.
Well,
They can say, well, we have to accept.
Well, just on, through all of this bargaining association model, we went through it, the employer identified that they had an issue with RNs and LPNs, their configuration of healthcare, bargaining unit, and the issue around mobility, and around if two unions are at the table, one's majority, one's minority, the majority settles for something that the minority doesn't want, how can you guarantee that the minority's not gonna do anything about it? We said, well, that's called democracy. But the other one was around benefits. So they were talking about sick leave, premiums, contracting out, privatization, long assignments, mobility, all of that. They're all negotiations. They should go to a bargaining table. Those issues remained on the table throughout this. So what they have clearly said to us in every single meeting is and this is why we thought they would just nail it down to these issues that they identified. But what the legislation says is that they can impose a collective agreement. And they have an absolute huge issue with the sick plan for public health, addictions, and continuing care, our members in the other 8 district health authorities, and capital health. Our sick leave is superior to others, and even some of our own members, and all the other unions believe that their plan is better, their sick leave is better, and so they know that there's no way, because we want to protect that in the bargaining association, which we don't have, we're not gonna get, so they brought it in so they can impose a collective agreement. And this is for this round, then we don't even go back to the table, you won't see a new contract under what they're proposing to probably sometime late 2016, 2017.
Let me just give I completely agree with Joan, a more technical answer to the question as I understood it. Go back to section 86. If you remember, this is the agenda for the mediator, and keep in mind that it then becomes the agenda for the arbitration phase. And you'll see in subsection 1 of 86, paragraph CI, the mediation and therefore the arbitrator has an option. The first option is to say that only one collective agreement is to remain in force for this new bargaining unit. So let's say we had a healthcare bargaining unit. There was some NSGU people in it, some QP people, some Unifor possibly people in it. So there's a number of collective agreements. One of the options is to pick one of those agreements and apply it to everybody. You don't get to ratify this, mind you. You don't get a say in this. And the other option they have is that all the collective agreements will continue in force, which means that then they would be subject to collective bargaining with the new employer. So the mediator has the option to talk people into doing one or two of those things, but as an arbitrator, the arbitrator would have the authority to pick one of the agreements.
Same person.
Now, the thing I've observed, and I've seen it over the years because there's been a lot of reorganizations of different things in the public sector, the winning union takes their own contract. 3 out of these 4 bargaining units, it ain't going to be NSGEU, the winning union. So it is not an exaggeration to say at all that the things in your collective agreements that are better than in other collective agreements are on the table, and more importantly, you don't get to have a say if they get taken away.
Just